Many advisors have assumed that as long as you ensure that the owner and payer of a life insurance policy has designated someone as an irrevocable beneficiary, then on death, the proceeds are protected for that person. Now, life insurance clauses are usually contained in separation agreements to provide security for spousal support. And when someone is named as an irrevocable beneficiary, then the owner may not change or revoke the designation without the beneficiary's consent. The insurance proceeds are not subject to the claims of the owner's creditors and do not form part of the owner's estate. A recent Ontario Superior Court decision is very important because it shows that there are circumstances where that will not be the case, particularly when dealing with life insurance clauses as security for spousal support. In the case of Dagg versus Cameron, the young husband had been formally separated from his first wife, and as part of the separation agreement, he named her as an irrevocable beneficiary of his $1 million life insurance policy. He then began a new relationship, and the couple had a child. That made his common law partner a spouse, and both her and their child dependents. The husband died unexpectedly from cancer. The second spouse and child were the only beneficiaries of his estate, which essentially had nothing in it. The second spouse made a claim for herself and her son as dependents. She went after the insurance proceeds which were payable to the first spouse. The judge easily determined that the second spouse and child were dependents. The question was whether the insurance proceeds were available to satisfy the second spouse's claim for support. Under the Succession Law Reform Act, any amount payable on death under a life insurance policy where the owner and life insured are the same person is available to satisfy a claim for dependent support. The first wife argued that the husband did not own the insurance policy when he died because he had designated her as the irrevocable beneficiary under the policy. Unfortunately for her, the ownership of the policy is not changed by naming someone as an irrevocable beneficiary. The first wife also argued that she was a creditor of the estate, so she should be able to claim the life insurance proceeds. But life insurance proceeds from the date of death are not subject to the claims of the creditors, certainly not of the insured when there is a named beneficiary. The first wife wasn't a creditor. She was a dependent, just like the second spouse and her child. The decision in this case, given the particulars, is probably a surprise to advisors and lawyers. It shows that life insurance proceeds on death may need to be shared amongst all dependents, even if there is an irrevocable beneficiary. What are some lessons? Watch out for another video clip.